In democratic societies, the law is regarded as the ultimate safeguard of citizens' fundamental rights. When those rights are threatened, individuals can turn to the courts for protection. But what happens when a judgment intended to uphold those rights proves flawed? This is where the recently discussed concept of a constitutional complaint against court decisions comes into play. To understand the idea, it is important to first explain what a constitutional complaint is. The Constitution is the highest law in the country, and if the state violates it, citizens can ask the Constitutional Court for help by filing a complaint. A constitutional complaint against court decisions goes one step further. It asks the Constitutional Court to review not only government actions, but also the outcomes of court rulings. In countries such as Germany, this type of complaint is widely allowed, and it has become natural for citizens to knock on the Constitutional Court's door as a final step if they believe a court judgment violated their rights. In contrast, South Korea does not treat court rulings as subjects of constitutional complaints. Why, then, has South Korea made it so difficult to revisit court judgments? The answer lies in the events of 1987. Under earlier authoritarian regimes, the courts were widely criticized for aligning with those in power and failing to safeguard citizens' fundamental rights. In the wake of the democratization movement, there was a strong push to disperse authority, ensuring that no single institution could become overly dominant. The Constitutional Court and the Supreme Court were designed to respect each other's domains while also providing mutual checks and balances. Over time, arguments for introducing a constitutional complaint against court decisions have grown, but opinions remain sharply divided. Opponents worry about creating a four-tier trial system. Normally, cases can be heard 3 times: first trial, appeal, and final appeal. If the Constitutional Court is added, the process would effectively become a 4th round. This could prolong litigation indefinitely, exhaust citizens, and weaken trust in court rulings. Supporters, however, argue that even one unjustly treated person is too many. Even if a law itself is not problematic, a judge may misinterpret it and infringe on citizens' rights. Because of this issue, the Supreme Court and the Constitutional Court have long been in conflict, each holding firmly to its position. The Supreme Court emphasizes that determining the correctness of judgments is the essence of judicial power and warns against intervention by the Constitutional Court. The Constitutional Court counters that court rulings are also exercises of state power and therefore should be subject to constitutional review. Ultimately, it is important to maintain trust in court decisions while ensuring that individuals who are treated unjustly receive full protection. As the country continues its pursuit of a more just society, the answer remains an open and pressing question.